Okay, everyone, there's one major new filing this week in the Don Lemon criminal case. Now, the government is asking the court for a protective order for discovery material that it's about to produce. Now, this includes documents and video recordings of interviews with the churchgoers who are the victims and witnesses in the case. Now, their personal identifying information and, in some cases, their medical information are on the video recordings and documents. The government says it will redact some of that information, but not all, because it wouldn't be feasible to redact all of it. And also, the defendants need enough information about the victims and witnesses to put on an effective defense that comports with the Fifth and Sixth Amendments. Now, this type of protective order is different from a restraining order that a victim of domestic violence, for example, might seek against an abuser. Now, this type of protective order governs discovery material containing confidential personal information about victims and witnesses, such as their social security numbers, birth dates, addresses, phone numbers, workplace information, names of minors, etc. So, essentially, it's a confidentiality protective order. Now, this type of protective order specifies the types of information deemed protected and limits disclosure to the parties in the case, which in a criminal case are just the prosecution team and legal defense team. Now, typically, this type of protective order also limits use of the protected discovery material to the court case and any appeals. So, sale of the protected discovery material to a news outlet would be prohibited. Sharing the protected material online, maybe to cause harassment of the victims and witnesses, also prohibited. Storing the protected material or making copies so that the defendants or the attorneys can write a best-selling book about the case, prohibited. Now, writing the book in and of itself is not prohibited by the protective order, but using the protected personal information of victims and witnesses in the book is prohibited unless the defendants obtain that information themselves through an independent source and not from the government's discovery production. Now, in my view, the protective order that the government is asking for here is typical, and apparently 33 of the 38 defendants in the case believe it's typical as well, because 33 defendants have agreed to abide by the proposed protective order after the court signs off on it. Now, these folks here, including Nakima Levy-Armstrong, Chantel Allen, William Kelly, a.k.a. Doe Oak Farmer, now they all agree to abide by the protective order. 4 of the defendants outright refuse to abide by the protective order. And 3 of those defendants are journalists: Don Lemon, Georgia Fort, and Shane Bowman. Now, the 4th journalist, Michael Walker Butte, he's Don Lemon's camera guy. Now, he hasn't responded to the government's communication yet asking for consent to the protective order, so he's neither a yes or a no at this point. Now, just to put it all into perspective, the defendants have been clamoring to get access to the discovery material in the government's possession for weeks, but maybe that was just theatrics, because we've all watched the video footage from the attack on the church already. Now, the government's interviews with those churchgoers will be a more detailed, in-depth version of the churchgoers' reactions on the video footage that we've already watched. And the government's recordings of those interviews contain personally identifying information about the churchgoers, such as their addresses and biographical information. Now, the proposed protective order is designed to protect that stuff. The protective order looks typical to me. Now, what the journalist defendants may be planning to do with the government's discovery material, however, is probably not typical. Now, if I had to guess, Don Lemon, Georgia Fort, and Shane Bowman are planning to write books about the case at a minimum. Now, the 5th defendant who refused to consent to the proposed protective order is Amelia Hansa. Now, she's not one of the standout defendants, but it seems defendant Hansa doesn't want to be grouped with the activist defendants. Now, what's not covered under the protective order? The defendant's own statements. So, the information on Don Lemon's cell phone and all of the defendant's cell phones are not covered by the protective order. The defendants can publicize all of that if they choose. Any information already on the public record or that makes it onto the public record and is not sealed is not covered by the protective order either. Now, under the Sixth Amendment, defendants have the right to a speedy and public trial, so the defendant's own evidence in the case, especially exonerating evidence and the government's evidence of the defendant's incriminating conduct, are not shielded from public view. Now, I'll emphasize a distinction here. When discovery material is presented at trial and is admitted at trial, then it becomes evidence. Now, before that, it's just discovery material, and the public has no right to view it per se unless it's on the public record of the case before trial. And according to the court's rules, confidential identifying information such as social security numbers, addresses, phone numbers, etc., have to be redacted from the public record. But sometimes even court personnel fail to uphold that requirement. Now, when Don Lemon was arrested, for example, his phone number was uploaded to the court's website inadvertently, and that type of thing happens all the time. All the time. So I understand the need for a protective order which provides for sanctions if protected information is leaked. Now, either this week or within the next 2 or 3 weeks, the attorneys for Don Lemon, Georgia Fort, Shane Bowman, Amelia Hansa, and Michael Walker Butte will file their oppositions to the government's motion for a protective order. So we'll find out then what their objections are to what I view as a non-controversial protective order. Now, generally speaking, discovery material isn't filed with the court. Filing with the court makes it part of the public record unless the material is filed under seal. Now, discovery material usually is shared from the prosecution to the defense and vice versa, and that non-public exchange of information facilitates plea deals. Now, before trial, discovery material makes it onto the public record only through court filings. Now, the vast majority of Don Lemon's co-defendants, including Nakima Levy Armstrong, Chantel Allen, and William Kelly, aka Doe Oak Farmer, all have no problem and consent to the proposed protective order, but the journalists refuse to abide by it. Now, when they file their oppositions, I'll break it all down right here. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.